Discussion and possible action regarding Fannin County Courthouse round, I guess it's 9, full restoration, final reimbursement monies from Texas Historic Courthouse Preservation Program, THCPP, Commissioners Court, Precinct 2.
Yeah, I sent you the email I got from THC. They're wanting to release the funds. They're just needing to say that the project's been completed and that we've got property insurance.
Okay, I have met with the commissioners from the Texas Historical Commission. I've explained to them where I am and that I will not sign the documents that they are requesting. Because the job is not complete, it would be untrue, it would be a false statement, and I took an oath on taking office to abide by the law, and I've got an obligation not to state an untruth.
This job was complete 4 years ago when you took occupancy of it.
I understand that that is what you've been told, and that is incorrect.
So let me ask you a question, Judge. Are you holding this $600,000 hostage till you get your way?
Am I, let me tell you what I'm doing. The job isn't complete. The $600,000, so you understand it, if it comes to us, it doesn't get spent. It goes back into reserves. Also, for your information,
It was pay the bond.
this money isn't making much interest. It's available, and the State Historic Commission says it's available when we ask them. They represent to them that the job is complete. This judge will not represent that this job is complete. I will not prevaricate myself.
Well, I won't either, but I think it is complete.
That's your opinion. Then
Well,
you,
that's your opinion.
no, it's
You're
what,
not an engineer.
it's what
I'm not an
it's what I
engineer.
understand. It's what I understand to be the truth
From who?
from engineers and electricians that I've spoken to.
Name.
I'd like to start with Robert Fleckenstein, and if you go back.
We've got a lady that wants to speak.
Well, sir, let me tell you this. I'm going to finish answering Commissioner Cost's request,
Okay.
and I was
Go ahead.
responding to it. But we will go ahead.
You didn't even acknowledge her. Is one thing.
Well, I haven't, we weren't through talking yet. She wasn't asked to come forward, was she?
No,
She came through the bar.
I did come through the bar because.
I know, but you weren't requested to come forward yet.
It's to a point of order, and let me just state something here. It would be nice if we could show some decorum in this court.
We are showing decorum, but when you come up without being called forward, that's not decorum.
Already setting the stage for me to be combatant, and that's not what I'm trying to do.
Okay, well, come forward and speak. I wasn't through speaking. That's sort of jumping in front of the bus.
Back out and come back in.
You can stand there now and speak.
Thank you. Okay. So what I'm about to share is based on public record, documented in minutes from 2021 and beyond. And this is all based on public attested minutes and any documentation that is provided, which I will gladly share with you after the meeting. I'll have to email them to you. Okay. So there's two crises that have evolved from this issue. Number one is uncollected debt and unfinished justice. On February 15th, 2022, the court voted to transfer $600,000 in American Rescue Plan or APR or ARP funds into the courthouse account to keep construction moving. This is based on minutes from 2/15/22. It wasn't a gift, it was a bridge loan with the understanding that the Texas Historical Commission would reimburse the county once the project was certified complete. In April 2022, the courthouse was declared safe for occupancy and signed off on by someone from Turner Construction. It was a substantial certificate of occupancy, and that is in the court records, and I believe it's on the 12/13/2022 minutes and or the 12/20/22 minutes. Okay. We moved back in, the work wasn't done, the bills weren't settled, but yet that was signed by them. Then on December 13th, 2022, this court, prior administration, was voted 5-0 to appoint the substantial completion certificate and authorize the county judge to sign it to receive the $600,000 back. 1 week later, Judge Randy Moore announced that the final certificate of occupancy has been received and was ready to be sent to the Texas Historical Commission. Let me read that one more time. A week later, Judge Randy Moore announced on public record that the final certificate of occupancy had been received, or it was a substantial certificate, had been received and was ready to be sent to the Historical Commission. That order was never carried out. And because of that delay, the taxpayers have been forfeited, I'm guessing, or not guessing, I figured like 80,000 plus in potential interest that money could have earned, which that's the unacceptable contradiction in all this, that it's not about the $600,000. It's about the pattern of how this courthouse has been handled from the start to now. The project has cost taxpayers over $30 million and it's still not finished, or is it? On one hand, Judge Cunningham, you have pursued contractors aggressively, authorizing lawsuits, hiring inspectors, and filing petitions to determine what was done and who is responsible. But we haven't got an answer to that. And then you've repeatedly told the public that repairs are ongoing, electrical hazards, flooding in the basement, HVAC problems, and structural issues. But on the other hand, you have written publicly, especially in 2025, that you are willing to sign a letter saying the county has substantially completed the project, but cannot in good conscience sign a letter saying the project is complete. And that was in your courthouse cover-up article in the Fannin County Leader dated 10/22/25. And that's the contradiction, sir. In 2022, while serving as an advisor to Judge Moore, and then you became a candidate for his office in 2021, and while you're campaigning, and then later on in July of 2022, I believe, you were appointed as pro bono counsel to the court. And where I'm going with all this is you watched the commissioners vote unanimously during that meeting to authorize submission of the same substantial completion certificate because you were present, you were there, it's on audio transcript. If the courthouse wasn't ready, that objection should have been made then, not 3 years later or 3.5 years later, citing an ongoing federal investigation in your courthouse cover-up article doesn't erase the fact that a 5-0 unanimous vote or the obligation that came with it is such an if such an investigation did exist, your own statements could complicate that investigation. By withholding a reimbursement already authorized by this court, it creates a blurred line between protecting taxpayers and to some, it appears to be using the courthouse as political leverage. And I'm speaking for what the public has said, not just what I think. And then meanwhile, we still have a courthouse that leaks, cracks, and sits $600,000 short of what the court has already voted to collect. So here's what I think you guys, just based on my parliamentary procedure memories and education, that you guys either need to follow through or fix it. On December 13th, 2022, the directive authorizing the county judge to sign and transmit the substantial completion certificate to the Texas Historical Commission still stands. There's no executive decision or anything to be made about that. That was a vote approved in 2022 and signed off on. I have the documents. If the court intends to honor that vote today, bring forth a motion to execute that directive as it stands in 2022. If not, then formally rescind it in open session on the record and let the minutes reflect that so that it would be clear. To restore fiscal clarity, have Ms. Alicia provide brief reports that show the APR transfer in 20, and you may already have that, I'm sorry. But the ARPA transfer from February 15th, 2022, the current, same thing, courthouse fund balances, and any THC receivable entries carried since December 22 and the estimated interest loss to date. And finally, you guys should adopt a public compliance tracker for all directives listing the action and dates passed and its completion status so that no future order quietly vanishes through the administrative oversight. And I'm going to point this out here. Mr. Fogelberg, you brought up the motion that you just.
Yes.
Okay. I look back on my little database of all the research and it shows the exact number of times that it has been, that same motion has been discussed in this court. And I can look it up in about 5 minutes and read it to you, or not 5 minutes, in 2 or 3 seconds and read it to you.
Why don't you read me what my commissioner here said last week when he said he wanted to look at the request? Read that to me. When we said we would provide them to him.
Let me get my phone.
Now, let me respond to a couple of things let me respond. Let me respond to a couple of things first.
Judge, this don't yell. It's comment.
Okay, well, let me go ahead and
Speak
respond.
softly.
I'm going to be
You
soft.
can respond.
Let me respond. Number one, I'm not going to be called down.
Point of order,
I'm not
Judge.
going to be, turn her mic off.
No.
Turn her mic off.
I move to the decision of the
Okay.
chair.
Calm down. It's
Look,
okay.
I want to respond. I get to
You
talk.
can respond, but do it in a peaceful
Okay.
voice.
Well, let me respond. She's trying to shut me down. Here's what I'm going to tell you.
Legally.
Substantial,
No, because I still have the-
substantial completion does not mean the job was completed. It means that it was 80% done. That's my understanding. I've also talked to Judge Moore. You know, certificate of occupancy doesn't do away with legal rights to proceed to get things fixed. Also, we've had several tens of thousands of dollars of things fixed that wouldn't have been fixed if we'd signed off on if we'd signed off on completion. If we signed off on completion now, we're going to have to pay over $100,000 immediately to the people who are doing the electrical work because we're representing all the work is done. If we sign a completion, I'm not going to sign a completion.
That doesn't release their license from the
It releases-
PDLR.
It releases their money. We've got to pay them. That's one of the things we're representing to the commission. It's over, it's done, it's complete. And I'm not going to do that. I'm not going to jeopardize our right to recover money on this courthouse. I realize why people are up here voting to do it. There's reasons that people up here would like this thing covered over and done.
That is not true.
That is true.
That is not.
What's my reason to do that?
Tractors,
Who?
equipment.
Tractor.
Tractors.
What?
You don't have a clue what you're talking
I
about.
have a clue that we have somebody who was indicted originally, has not been
Point of
acquitted,
order.
and who may find themselves back in the cooker. And I realize that he is pushed to keep us from investigating this thing to determine what else is wrong with the courthouse. And I realize that he's been voting to push equipment to people.
What? What are you talking?
What are you giving me, AJ?
What in the world?
Okay,
You're off in left field.
I'm not off in
wasn't
late
done.
field,
It was just-
on track. Let's go ahead and vote. Are we going to vote to,
Order, sir. I still have time.
okay, go ahead and speak. Your time is up.
It is.
Based on what?
No,
On the
Commissioner
three,
Smith, more time to speak on this?
okay, you can have more time to speak
Thank you.
if they want you to. Would you like to?
I'd like to give her more
speak?
time.
Let's hear more.
more.
Now, remember, all this is based on public documentation. If you look at the Texas Local Government Code, section 81.006, court acts remain in effect until rescinded or amended. Nowhere in any documented minutes or attested minutes has a motion to rescind been taken, which would have been it. Or had the motion to reconsider the vote on the 12/20 or the 12/13/2022 5-0 unanimous decision on that, nor was that motion reconsidered at the next meeting. And therefore, that's not even an option anymore. But if you truly wanted to reflect transparency in this court, you would have somehow in the middle of all this rescinded that motion and had the commissioners court vote on that. Hold on. So, and here's what I mean. Your court acts remain in effect until the item is rescinded or amended. Then Titus County versus Agan in Texas 1997, which is a Supreme Court case, the execution of lawful court orders is ministerial and not discretionary, which is the key here. And I understand to a point where you may feel like you're standing on a crossroads between what's right and what's wrong. But you, sir, as an attorney should know that you cannot reverse an action that is voted on by this court without the effective or the correct motions to do so. And I've tried to see both sides of this and I just can't. And then, and it's plus the whole Opens Meeting Act issue with this, when anyone gets up here to try to speak to you or explain the open public record, things that should be clear and obvious because you do base transparency. It's in every article, it's in every meeting. And I get it. But you're not allowing the citizens to speak without shutting them down and taking it as a personal attack. Whenever you yourself told me over there, the first time you met me, that, you know, you knew if you were in court and a judge looked at you, you knew when to shut your mouth. And I wasn't quite sure how to take that, which is kind of why I've been quiet for a little while. But what I'm saying is, I'm not trying to give you legal advice. I'm stating the facts based on the Texas Local Government Code, the Open Meetings Act, and the public record of minutes that have been attested and approved by this court. And so all I'm saying is, when everything is recorded properly, the rules don't forget, the minutes don't forget, and the actions by this court should not be forgotten or to be twisted into, or not twisted, should be used to stand on your executive discretion. So failing to collect this money adds to the cost of the courthouse, the cost of litigation, and the cost of public trust. The record's clear. The vote was lawful and should still stand, and that order does stand. So execute it, rescind it, but do it on the record by vote, and for the sake of transparency, do it in public. Any questions?
No, and I thank you for your opinion, even though you say it's not legal.
Excuse me?
Even though you say it's not a legal opinion.
I don't understand what you're saying.
It's not a legal opinion.
Mine is not, no, it's not a legal opinion, but anyone with common sense can read these laws.
Anybody with a law degree would know you're incorrect.
Absolutely.
Yes, ma'am.
Right. Anyone who has a basic knowledge of the law or any kind of public documentations, of course, doesn't know what they're talking about because they don't have that title, sir. Come on.
All right, gentlemen, let's get back to it. I will not sign a document showing that the courthouse job is complete, period.
So you're just gonna hold up the public's money?
No, you're holding up the public's money by not having an inspection. If we get an inspection and they tell me it's complete, you
How
may
come?
find my attitude change.
Judge, we've been in this courthouse for 42 months.
And you've kept me from taking your deposition to find out what happened here for over a year.
I kept you from taking
You-
my
you
deposition.
sure
You
did.
got my deposition.
Yes, in December, 20 days before our DA was going to be out of office.
What does
And I
that
got
have?
your deposition and you provided me nothing that was helpful.
Well, then you didn't have any.
That's probably why
You
the
ain't
case
got
got
nothing for
dismissed for
nothing.
lack of
Okay.
evidence.
Argue with you. I'm telling you where I am. I will not sign it. I will go on public record indicating that I do not believe this courthouse is complete and I believe it's a cover-up. And that's
What?
where I am on public record.
What's not complete?
What's not complete? I can give you a list of what's not complete.
What?
Give me
Okay,
this.
list it.
This.
Okay, I've got a book full of things that aren't
List
complete.
it.
Your books.
We need to
usually
go
do that.
inspect every one of those things,
Okay.
item by.
I'm not going to sit here today and go over item by item. I'm telling you that I will not sign anything that this is complete.
So we're gonna just continue to lose interest on the money that we
And
borrowed.
we're going to lose 4.1% of 300,000 because we're going to have to pay
600,000.
money to the contractors that aren't through yet before we can get to 600. If we say it's complete, we're saying it's fine and the contractors get their money. That's not in, I'm not going to do that. Now, if we want to look at this a little deeper and come back and talk about whether or not we go ahead and approve paying it or accepting it, we can, but I will not sign it. You can approve it, but I'm not signing it.
I
Well, if
believe
you don't
it's-
sign it, we ain't getting it.
I believe it's court order if we vote on it, that you sign it.
I will not sign it.
You're not gonna sign a court order?
I'm not going to sign the court order. I'm not going to do something that I think is not only unlawful, but untrue and goes against my basic oath of office. I will not do that. Now that we want to have a motion and a vote.
I'd make a motion, we accept the final restoration reimbursement money from the Texas Historical Commission Preservation Program.
Okay, we've got your motion. Do we have a second?
I'll second.
We've got a second. I would suggest you abstain from voting on it, but you're going to second it, so I guess you're going to vote on it. Let's
You
go
his
ahead.
lawyer or something?
Yeah, you're not my attorney.
I'm suggesting, I'm not giving him legal advice. Let's,
You just did.
I did not. Let's,
Yeah, you did.
Good.
okay,
You sure did.
let's continue on. Let's go ahead. We've got a second by Commissioner Self. Let's go ahead and vote. Precinct 1,
Aye.
precinct 2,
Aye.
precinct 3,
Aye.
precinct 4,
Aye.
and I vote no.
Don't.
Motion passes.
No, it does not. With you doing that. The motion did pass. You're right.
I said the motion passes.
Well, good. Now sign it.
I'm not going to sign it. Get a court order requiring me to sign it.
Well, that may not be hard to do.
Okay, they'll get a lot of testimony. Okay, let's proceed on. The motion passes. Let's proceed on to